Start para. Sri Ramanand Pandey, the learned additional Chief Standing Counsel, while opposing the said submissions advanced by Sri Bhanoth, has contended that the 1985 rules and more particularly Rule 1 in bracket 2 thereof clearly prescribed that they were to come into force at once. Full stop. Sri Pandey consequently submits that the 1985 rules would be deemed to have come into force on 16th March 1985 itself. Full stop. According to him, merely because these rules dated 16th March 1985 came to be published in the Gazette only on 31st August 1985, this would not have the effect of postponing the date when the rules would be deemed to have come into force. Full stop. According to Sri Pandey, the use of the words at once in Rule 1 in bracket 2 unambiguously established the legislative intent of the rules being made enforceable from the date of their making and would therefore be deemed to have come into force on 16th March 1985 itself. Full stop. Consequently, he submitted that no appointment post 16th March 1985 could have been made without following the procedure prescribed therein. Full stop para. Before we deal with the primary issue canvassed before us, it becomes apposite to note that the order of termination did not rest upon this issue alone. Full stop. Admittedly, the government order dated 31st October 1985 clearly held the field at the time when the appointment of the appellant came to be made on 18th April 1985. This government order clearly prescribed the year of recruitment to commence from 1st July and to end on 13th June of the following year. Full stop. We further note that the government order dated 31 October 1984 referred to the subordinate offices, clerical staff in bracket direct recruitment bracket close 4th Amendment rules, 1979, which appears to have governed the file till they were suspended in their operation by the government order dated 31 October 1984. Full stop para. The suspension of these statutory rules appears to have continued till the promulgation of the 1985 rules. Full stop. During the interregnum, the provisions of the government order dated 31 October 1984 appears to have occupied the field and governed the subject of selection to post in the subordinate offices in the state of UP. Full stop. This government order prescribed the composition of the district selection committee and the procedure to be followed by the said selection committee while effecting appointments to post in the subordinate offices of the states. Full stop. Admittedly, the appointment of the appellant came to be made on 18th April 1985 prior to the commencement of the year of recruitment as prescribed under these rules. Full stop. We note that the learned counsel for the appellant was unable to establish before us that this objection noted in the government order dated 23 September 1985 was either unjustified or unsustainable. Full stop. In our considered view, this objection noticed in the impugned order dated 23 September 1985, was sufficient to sustain the termination of the temporary engagement of the appellant. Full stop. However, since much argument was advanced on the issue of commencement of the 1985 rules, we proceed to deal with this contention also hereinafter. Full stop. Reverting to the fact of our cases, we find that the contention advanced on behalf of the appellant must necessarily fail on the same ground. Full stop.